Good afternoon, colleagues. Thanks for joining. My name is Konstantin Kroll. I'm a partner with Dentons in Moscow and head of Dentons Russian corporate and M&A practice. Thanks for all who have joined. I can see more joiners joining us every minute now. I have a last-minute announcement to make. Unfortunately, our moderator of the day, Roman Zykov, partner at Mansur's law firm and Secretary General of the Russian Arbitration Association, unfortunately he fell sick. I'm afraid it's Omicron, so he had to excuse himself and asked me to step in as a moderator today. I'm sending our joint wishes of soonest recovery to Roman, and that's just another reminder for all of us to stay careful as the risk is still out there, so the threat is there. Let me introduce our panel today. I'm joined by distinguished colleagues, Vladimir Melnikov, partner at Linklaters International Law Firm, and Sergey Lysov, senior associate at Gudkov, Kalatilov and Partners, Russian independent trial law firm. So all of us, we've met many times discussing sanctions subjects, so it's not the first time we'll be covering this topic, which
so it's something we do have an existing track record in doing, but it's nothing that we've really previously gone to market as having.
I do apologize for this interruption. May I remind our audience to please kindly stay on mute, if at all possible, and we shall open the floor towards the end of our session for questions. So without further ado, let's start. So thanks to Russian Arbitration Association for organizing this event, as always. So, Victoria, may I ask you to open an introductory slide? The way we're going to structure our discussion today, so we're going to discuss impact of sanctions on international arbitration. On the agenda, I will start with just briefly reminding us all about what the sanctions are and how do they impact arbitration. Then Vladimir will talk about Russian counter-sanctions measures. After that, Sergey will discuss amicus brief provided by the Russian Arbitration Association in relation to the key case on the subject. And I will conclude by briefing you on the RA's study on the impact of sanctions on international arbitration, after which we'll open the floor for questions and we'll have a discussion. So thank you, Victoria. You may close the slide now. So very, very briefly, colleagues, because of course, I believe you are very well familiar with the phenomenon of sanctions. Unfortunately, since 2014, it has become our new reality. But worth reminding that one of the key problems and complications with the sanctions is that they're not contained in any one piece of law. There is no one place where you can look at them and understand them. Each jurisdiction has its own, sometimes they're described as programs. So we use this term for lack of better ones. So sanctions programs, of course, US sanctions programs are some of the most spoken about because of the impact they have and the role US jurisdictions plays globally. But of course, EU sanctions are also some of the most relevant from the Russian perspective, and there are also sanctions imposed by specific other jurisdictions, and importantly, the United Kingdom of Great Britain, since Brexit and since leaving the EU, has imposed its own sanctions. Now, if we start with the US sanctions, as I said, they're not contained in just one place. It's not a single program. The key aspects to remind us is first that all sanctions can be divided into the so-called blocking ones, where US have so-called specially designated nationals and blocked persons, so SDNs, and that's those individuals and legal entities that US persons are prohibited from doing anything at all. Then there is also sectoral sanctions program, which is less severe, and that only restricts certain types of activities with those under sectoral sanctions, but not all of the activities. Then there is a separate Crimea-related sanctions program, basically restricting pretty much everything you can do with the Crimea. Then a very important legal act is the so-called KEATSA, or US Countering America's Adversaries Through Sanctions Act of 2017. And a very important aspect of that law is that it includes so-called secondary sanctions in relation to non-US third parties that enter into significant transactions with SDNs. So that opens up the risk not just to US persons, but pretty much to anyone transacting with an SDN, because there is a risk of falling under secondary sanctions. And it's a complete state of the art what is significant transaction, what is not a significant transaction. So that's we could have a separate seminar just on that subject alone. And finally, important thing to remember that once the sanctions are imposed, it doesn't mean that nothing can be done with a sanctioned person. It means that in order to transact with the sanctioned person, including SDNs, the blocked persons, one needs to receive a license. License is effectively permission of an authorized regulator allowing you to deal with the sanctioned person within the scope of the license. And the regulator in the US, which is authorized to grant such licenses, is the Office of Foreign Assets Control of the US Treasury, or OFAC. So that's a key department for these purposes. Now, if we look at the EU sanctions, again, very briefly, there are certain similarities with the US sanctions, because EU sanctions also can be divided into the so-called smart or targeted sanctions and sectoral sanctions. So smart sanctions, they prohibit all transactions and dealings with specific individuals and entities, or so-called targets. So that's similar to SDNs. And then sectoral sanctions prohibit certain types of dealings with entities within the industries under sectoral sanctions. And mostly that would involve equity and debt transactions with those entities. So for example, just to illustrate, there is a maximum period for which a loan can be provided to an SDN. Sorry, to an SDN, nothing can be done. Sorry, to sectoral, we talk about sectoral sanctions. So it used to be 30 days. Now it's down to only 14 days to which financing can be extended, like financing or equivalent. And let me illustrate, because a lot of those in the audience are lawyers. So from our perspective as lawyers, we can advise entities under sectoral sanctions that would not breach the sanctions. However, if they pay our bills later than 14 days, then effectively we are financing them. Right? It's some kind of trade finance, and we may be in breach of sanctions. So, which means that they need to pay our invoices on time, otherwise we're in breach. So I think that we all like clients paying our invoices quickly, but what we don't like is the risk to fall under sanctions. And of course, in the EU example, it is also possible to ask for permission or license from the regulator, and if you fail to meet the requirements, you can be penalized. But the complexity is that each member state of the EU would have its own regulator. There is no one uniform body. So, for example, in the UK, it would be the UK Office of Financial Sanctions Implementation, OFSI, and in other member states there will be other state bodies who deal with the sanctions matters. So, so I think that's enough of the sanctions background. And of course, we can talk further about the prospects of new sanctions that we'll read about in the press, but that is two unpleasant subjects on which I don't want to waste any more time, quite frankly. But we can come back to that later. So how all these sanctions may impact international arbitration, one may ask. So there are plenty examples of how this may happen. And there are both sort of legal problems and practical problems. So both present a serious predicament for those involved in international arbitration. So first, I'd start with saying that sanctions imposed by a state, it can be argued that sanctions form part of mandatory provisions of applicable law of that state. So, for example, if a contract is governed by English law and the UK has imposed certain sanctions, then arguably sanctions become part of the applicable law of the transaction. So, but that is a theoretical part. Now, if we look at practical problems that arise, let's say there is an arbitration and one party is under blocking sanctions, an SDN. So what means that first of all, that party won't be able to pay its arbitration fees because simply the bank would not accept the payment, or it will freeze the payment. And that would certainly happen if the payment is in US dollars. It may well happen if it's in euros. It may even happen if it's in another currency, because many banks are extremely cautious and worried about penalties they may fall under. So it becomes a real problem. Then hiring a legal counsel in a cross-border context, a party would want to be represented adequately in a dispute. So that means that a US law firm, for example, would not be able to act for an SDN because of the risk to breach US sanctions. But same may be true of an international law firm with offices in the US. Same would be true of US citizens working outside the states, elsewhere. And of course, there is a reputational angle there as well. And as I said, it is possible to obtain a license allowing you to represent an SDN, but obtaining a license may take a lengthy period of time. Generally, OFAC would grant a license for representation in a legal case, but it may take months, and the outcome is not guaranteed. And that is one of the key problems. Same problem would come up when you need to appoint an arbitrator, because arbitrators from citizens of jurisdictions that impose sanctions would have a problem accepting nomination, or at least they would need a license. Then there could be issues from the arbitral institution itself, whether it can administer a dispute involving sanctioned entities, but most international arbitration institutions have now adopted certain rules how to deal with that. Then you have issues appointing involving experts, pretty much the same as a law firm, and even bringing witnesses to testify. If a witness is under blocking sanctions, that witness won't get a visa or permission to travel. And of course, you would say that nowadays with COVID, everything is online, but that would hopefully not be always the case. And of course, a person may join virtually online when everyone else is in the room, but that may itself give floor to an argument that personal party is not on equal terms with the others, that it's limited in presenting its case. So I think all of this just gives you a flavor of what kind of problems come up in the arbitration context if a party is under sanctions. So without further ado, I would give floor to Vladimir Melnikov, who is going to discuss some of the countermeasures that the Russian state has adopted to deal with these issues and, so to speak, to protect parties under Russian sanctions, though it remains to be seen, and Vladimir will explain whether these measures have helped or have created more problems. So let's see. Vladimir, the floor is yours. Thank you.
Thank you very much, Konstantin. Thank you very much. Good afternoon to everyone. Maybe good evening. Yes, sanctions, they're becoming more and more popular in the modern world. And in June 2020, an amendment was adopted to the Russian Procedural Court. And in this amendment, by the way of this amendment in the Russian Federation, it was an attempt to protect interests of Russian persons affected by sanctions. In fact, the amendment introduced two articles, Article 248.1 and 248.2. The purpose of Article 248.1 was to stipulate that Russian courts have exclusive jurisdiction to deal with the disputes involving a Russian person affected by sanctions or a non-Russian person affected by sanctions addressed against a Russian person. Sort of a secondary sanctions, as Konstantin just noted. The second article, Article 248.2, was to provide Russian courts with the powers to issue anti-suit injunctions if the exclusive competence of Russian courts is breached, and a right to issue a penalty, a remedy of penalty, to police compliance with anti-suit injunctions. So basically, quite a powerful remedies were granted to Russian courts, and as far as I understand, this is the first time when Russian legislation provides for this type of remedies. So basically, the reasons why these amendments were introduced were actually addressed by Konstantin, because there are a lot of different problems related to a party affected by sanctions to litigate in jurisdictions which basically recognizes the sanctions. After these amendments to the procedural code were introduced in the legal society, there were a lot of debates how these articles should be implemented, interpreted, and applied in practice. And I even have to confess that even in my firm, Arbitrators, there were different opinions between different partners. My position, and at the time, was a strong view that in order for an affected party to involve Article 248.2, it's necessary to prove, to demonstrate to the Russian court that the sanction somehow limits its ability to litigate fairly at a foreign forum. So it was my position at that time. And ironically, soon I was given an opportunity to test my position in practice, because I was instructed to be a counsel of PESA in a landmark case between PESA and Ural Vagon Zavod and Ural Transmash. This is that case where the Supreme Court of the Russian Federation ruled and decided how these articles should be implemented and interpreted in practice. By way of background, initially, Russian courts were sympathetic about the position I just told you, that it's necessary for an affected party to prove that sanctions somehow related to its right to judicial protection. And the court of the first jurisdiction, the arbitration court of Ural district, and even the judge of the Supreme Court of the Russian Federation, judge, agreed that new articles should be interpreted under these new articles. Ural Transmash were bound to prove that European Union sanctions applicable to this company should somehow affect its rights to arbitrate in Stockholm. And given that Ural Transmash were unable to provide sufficient evidence, on the contrary, the evidence strongly suggested that he was able to protect its rights, courts refused to grant anti-suit injunction. So, at the moment when the Supreme Court, the judge of the Supreme Court refused to give a leave for the cassation appeal to be heard by the Supreme Court, I was about to celebrate a victory and having some jokes with my partners who were about the different opinions how this article should be implemented. But unfortunately, for my position, the head of the economic division of the Supreme Court of the Russian Federation, Judge Podnosova, came to a different conclusion, and she instructed the cassation appeal to be heard on substance by the Supreme Court of the Russian Federation. And as a result, a panel of judges issued their ruling. And they decided actually that it's not necessary for an affected party to prove that the sanctions are somehow related to somehow limited their procedural rights or otherwise create an obstacle for an affected party to defend themselves at the foreign forum. They said that it's sufficient for an affected party to demonstrate that the litigation or arbitration took place at the country which issued sanctions affecting this party. And by itself, it's sufficient for the Russian court to assume the exclusive jurisdiction over this dispute. And it can be also a basis to issue anti-suit injunction if necessary. In that case, then this anti-suit injunction wasn't granted, but the interpretation, the binding interpretation is there. Accordingly, now the position is that all Russian persons affected by sanctions are basically able to walk away from the existing arbitration clauses, and they are able to apply directly to Russian courts or seek anti-suit injunction to prevent arbitration and litigation in the foreign forum, provided that this forum is located at the country which joined sanctions against Russia concerning this affected party. Given that quite a lot of companies are generally affected by sanctions because it's also applicable to general sanctions, it's not also only applicable to SDM. It means that there is a significant uncertainty now whether a great number of arbitration clauses are workable from a Russian procedural law perspective and from the position of Russian courts. Clearly, from a procedural position of foreign courts or potentially position in tribunals, it doesn't really matter, but from a position of Russian courts, the situation is very different and give an option to Russian affected persons to protect their rights in Russian courts instead of proceeding in accordance with dispute resolution clauses in their contracts. Another question which is left to be decided in the future is whether if whether the arbitration dispute resolution clauses and concluded after introduction of sanctions against a particular person, whether this arbitration clauses are workable or they are also not workable, because basically a party, an affected party, agrees to litigate in London after the fact that it is aware that England introduced sanctions against Russia concerning this person. So it may be interpreted as an agreement that nevertheless I trust English courts, for example, but it's a question which is left to be decided. And as the things are staying now, there is a big concern that these clauses are still workable. So this is all I wanted to say. So I give the floor to Konstantin.
Thank you, Vladimir, for this excellent summary. We have a question from the audience from Anton Maltsev, but I would suggest that we answer that and other questions at the end of the presentations, not to interrupt the flow. But please do send them in the chat in the meantime, and then we shall address them. So now let me ask Sergey Lysov to talk about the amicus brief provided to the Russian Supreme Court in connection with this very important precedent case that Vladimir has described. Sergey, the floor is yours. Thank you.
Yeah, thank you, Konstantin. Just give me a second to open the presentation to share my screen. Well, good evening, everyone.
Yeah, we can see your presentation, by the way, so everything works.
Okay, great. So do you see the entire presentation, or do you see just the structure of the presentation?
We see the main slides in the center, and on the left we see all the slides. Yeah, now we see them. Yeah.
Well, now
perfect now.
Yeah. Great. So I'm going to share our experience, in preparation of quite a specific documents for Russian court system, which is an amicus curiae prepared by Russian Arbitration Association and filed in the case which was discussed by Vladimir, which is the Ural-Transmash case. But first of all, I would like to introduce our working group, which actually made it possible to prepare amicus curiae. The working group was established in 2016 within the auspices of the Russian Arbitration Association. Before 2012, before 2020, the group was headed by Sergey Usovskin. He is a prominent Russian arbitration practitioner. I'm sure most of our listeners are aware of. And now the group is headed by co-heads Marina Zinkova, Oleg Todor from Whiten case, and me. And has more than 30 group members from Russia, France, Italy, Switzerland, Hong Kong, and Sweden. We're trying to expand the group by involving practitioners from all over the world. So everyone who is interested actually in developing Russian case law and arbitration is invited to take part in the preparation of amicus curiae in our further projects. So for the last 6 years, 11 amici curiae was submitted to the Supreme Court, including the amicus curiae in Ural-Transmash case. And what is notable that each amicus was prepared by conflict-free group members. So each type, given that we have almost 40 lawyers, from different law firms and different jurisdiction, it is quite possible to create a working group which is free of any conflict. what actually happened in Ural-Transmash case as well. Here on the slide, you could see the members of the working group. I will not list, I just listed everyone and wanted to once again to say huge thanks because these people made possible to prepare the amicus curiae and were involved deeply in the preparation of the document. Here, there's the front page. I'm not recommended to read it because I'm sure that the letters are small, but this is just to demonstrate that the document was solid. It contains the stamp of the Supreme Court that it was already confirming that it was filed to the Supreme Court. You can read the whole text of the document on the Russian Arbitration Association website, and there will be also a link in my presentation, and you can find it on our website, arbitrations.ru. About the jurisdiction, so the amicus curiae contained the analysis of 6 different jurisdictions, including England and Wales, United States, Italy, France, Canada, and Switzerland. And the issue here, which made it a bit complicated for the analysis, is that Russian anti-sanctions legislation is something unique, which actually doesn't exist in any of these or other arbitration-friendly jurisdictions. So the certain limitation exists only in China, to the best of my knowledge. And we didn't find any case law from China, unfortunately, although it might exist. But the core idea of the amicus was to analyze what restrictions do court actually recognize as preventing a party from its right to access to justice in these jurisdictions. So that was the subject of our analysis. Because, as Vladimir mentioned, there were indeed debates on the application of Russian anti-sanctions law. For instance, on this slide, I summarized the content of Article 248.2 of the Commercial Procedure Code, which is devoted to the interim injunctions, anti-suit injunctions, which could be requested by Russian sanctioned party from Russian court. The main point, in my opinion, is the last one. So sanctioned party might apply the Russian court for anti-suit injunctions, which happened actually in Ural-Transmash case. The injunctions could be applied both against the ongoing and expected foreign proceedings. And the law also provides the penalty, which, according to the law, should not exceed the amount of the initial claim and the legal cost. But the most important is that the party seeking the injunction is required to prove the circumstances confirming the exclusive jurisdiction of Russian courts, including that the arbitration or prorogation agreement is incapable of being performed. So the core issue here is what is the content of this term, incapability, whether it means that the sanction itself make the arbitration or prorogation agreement as incapable of being performed, or there should be additional evidence presented by the party. And in the amicus curiae, we concentrated on 2 approaches, specifically in the cover letter to the amicus curiae. So we stated that there are 2 options for the Supreme Court to decide the case. And the first approach is that the mere introduction of sanctions is enough to establish the exclusive jurisdiction of the Russian court. And this approach was proposed by the judge, the deputy president of the Supreme Court, Judge Podnosova. And the second approach is that in each case, the court should establish individually whether the sanctions affect their right to access to justice before application of Articles 2481 and 2482 of the Commercial Procedure Code, meaning that the court should analyze whether there are particular problems with hiring lawyers or certain limitations with respect to bank transfer, which might preclude party from payment of the registration fee or any other payment which is necessary to initiate arbitration or proceedings, or to continue the existing arbitration proceedings, or there are some visa issues, or at the end of the day that the sanctions imposed are somehow connected with the substance of the claim, which, as I understand from the lower court's judgments in Ural-Transmash case, actually did not take place in this particular case, because the Vladimir might correct me, but the judge in Yekaterinburg stated that the sanctions imposed have no connection to the subject of the claim. So, and this approach, the second one, was supported by the courts of all analyzed jurisdictions. At the same time, the first approach, as we highlighted specifically in the cover letter to the amicus curiae, creates certain risks not only for foreign companies, but for Russian companies as well, because it appears that by trying to help Russian sanctioned companies, the legislator damaged crucially their system, or the whole system of the international commercial trade, and it became actually the foreign companies would think twice before entering into transaction with a Russian company, because even if it is not under sanctions so far, it might became a sanctioned entity after or within the execution of the contract or at the time when the dispute arises. However, we will know what approach was finally taken by the Supreme Court. Unfortunately, it was the first approach. I summarize it on the slide. And the third point summarizes the whole judgment, is that the mere fact of the sanctions is sufficient to conclude that access to justice has been limited. Notably that although the judgment was adopted only in December 2021, so slightly more than a month ago, there are two more cases where courts referred to Ural-Transmash case. These are Power Machines versus Vostok Energo case and Tsargrad Media versus Google case. And I'm afraid this is only the beginning, and during this year we'll evidence more and more cases where the issue of injunctions will appear. And here on the last slide, I also would like to share some legislative developments that the situation might be even more complicated, because one more initiative was proposed by the member of the Russian Parliament, Lugovoy, who actually was the initiator of the first law, which we discussed in details a bit earlier. This law would be considered in March 2022, and it provides for even widening the scope of the application of the recently adopted anti-sanctions law. And it provides also for liability of the persons who provided financial or political support to initiators of sanctions, and which is quite vague Unfortunately, this is a direct quote from the bill, the translation of the bill. And however, it still remains to be seen how the initiative will actually be amended in the parliament during the first three hearings. But this is what should be monitored and should be taken into account while entering into transactions with the Russian parties. Well, as to the outcome of the case, there are a few questions left. Firstly, how the articles of the Commercial Procedure Court should be interpreted. Should the sanctions be imposed by lex arbitrary jurisdiction, or is it possible to choose the neutral forum? And this question is one of the questions which actually I saw in the chat. And I think that would be very interesting to discuss it with the panel. When the other question is that should foreign companies execute the injunction and proceed in Russia as claimants? What would be your recommendation to the client? And this is also a question which could be answered, in my opinion, ad hoc, actually, depending on the circumstances of the case. The third issue is that if a foreign claimant decides to proceed in Russia from the very beginning, for example, ignoring the dispute resolution clause, which was initially in the contract, with referring to Russian anti-sanctions law, whether respondent, a sanctioned entity, would be stopped from the jurisdictional objections. And in the end of the day, whether the Russian court judgments would be enforceable. I mean, the judgments which would be issued at the application of foreign claimants as a result of the injunction against the foreign proceedings. So these are answers, these are questions which requires answers, and it still remains to be seen how the situation would be developed. And in my opinion, the Ural-Transmash case, unfortunately, is just the first step, the first brick in this sanction wall. The last point which I would like to raise is that everyone is invited to take part in the activity of the Russian Arbitration Association, and specifically in the Amicus Curiae working group. And we hope that this is the perfect way to express the opinion of the arbitration community, that certain things should be decided not in the way actually Russian judges got used to decide them. And to express our disagreements. So this is a perfect way to make them hear us. And I'm sure that the judges in the Supreme Court read our documents and take them into account. So that's it. Thank you very much.
Thank you very much, Sergey, for this excellent and detailed summary. And indeed, thanks to the Russian Arbitration Association and everyone involved in the preparation of the amicus brief, because I agree with Sergey that that is a very important opportunity to convey sort of message from the market participants to the court. And I agree that the judges must have read the brief. Where I would disagree perhaps with Sergey is that I don't necessarily think that the judges have taken it into account. My personal view is that the outcome was predetermined, and it was rather more political than based on pure legal considerations. And I think that it is very important that there is this new draft law which will be heard by the Russian parliament in March that Sergey has mentioned, and I think that the prospects of that law would very much depend on whether there will be new severe sanctions imposed by the US or other jurisdictions before March, because it seems that Russia as a state retaliates or responds to sanctions. So these are countermeasures, and the more severe the sanctions, the more severe might be the countermeasures. Well, we don't have much time left, so let me just say a few words about about the report that was commissioned, prepared by the Russian Arbitration Association on the implications caused by the sanctions on the market. And because we don't really have much time, and I'd like to leave time for discussion, I would just say that, first of all, this is not the first survey of the kind. The first one was done in 2016. So this is now a second one. And this is a very representative survey. So about 200 practitioners, both in-house and from private practice, were asked to respond to 10 questions addressing key sanctions-related issues. And what these answers have revealed is that significant proportion of market participants have noticed and witnessed that sanctions did impact arbitration proceedings, whether at the level of the arbitral institution or in terms of a party's ability to pay arbitration fees or instruct counsel. And an important observation which can be derived from the survey is that the role of the Asian arbitration centers, the Hong Kong International Arbitration Center and the Singapore International Arbitration Center is growing. So the place of this institution in the survey is going up, and the popularity of choosing Hong Kong or Singapore law as applicable law to the transactions is growing up. And as I expect my colleagues on the panel would agree, that we see more and more Russian market participants, in particular state-owned, opting for arbitration venues in Asia, because neither Singapore nor Hong Kong have imposed any Russia-related sanctions, and sanctions are not part of the applicable law of these jurisdictions. And importantly, both these forums are accredited by the Russian Ministry of Finance. So this is more of an argument relevant to corporate disputes, certain other types of disputes that are only limitedly arbitrable. But that is another argument in favor of these institutions that the decisions would stand. So before opening floor for questions, let me just conclude, wrap up by saying that, of course, as you might have already thought, that whatever decision granted by Russian court or any penalty imposed by Russian court may not be enforceable outside of the Russian Federation, well, at least in the absence of a treaty on recognition and enforcement of court judgments. However, any assets of a non-Russian or non-complying counterparty that are in Russia would be at risk, and such assets may include money in the bank account or shares in Russian subsidiaries. And of course, in theory, and this might be a remote risk, but yet there is a risk of criminal liability for non-compliance with decision of Russian court. So something to be aware of. So again, thanks to Vladimir and Sergey for their presentations, and let us take questions from the floor. So let's first address those that were already asked. So first, the one by Anton Maltsev. So questions: what if the seat of arbitration is in a sanctions neutral country, such as Singapore, but the substantive applicable law comes from a country that does recognize or has imposed sanctions, for example, the UK? What is our take on it? So, well, personally, my take on it, that's the tribunal would need to apply applicable law as it is, and there is a strong argument that sanctions form part of English law as applicable law of the contract. So that is my view. Vladimir, Sergey?
Yes,
please.
I think that in the context of this question, I believe that for the purposes of Russian anti-sanction law, it's also be seen, because if the tribunal, which is if the arbitration institution which is managing the arbitration procedure is based in an EU country which issued sanctions or joint sanctions. It's related to the point how this tribunal would manage appointment of the tribunal, basically, because the president of the tribunal would be probably appointed in most cases by this arbitration institution. And this is the core of the ruling of Judge Podnosov, which said that there is an issue of objective impartiality, and it cannot be basically guaranteed, following her logic, that in this particular case, the arbitral institution wouldn't appoint a person which has some prejudice against the person affected by sanction, or this type of logic may play. And on this basis, I believe that the problem is not only its location of the arbitration institution. I think it's the most important problem here, because the seat of the arbitration, parties are free to decide where is the seat, but who is in charge of appointing the tribunal? This is the key. It's my view, at least.
Well,
thank you, Sergey.
Yeah, as I understand, what Anton is asking is that if the substantive applicable law comes from the country which recognizes sanctions, and in this case, I think if a tribunal is neutral and the applicable law is, for example, the English law, it should be analyzed how the substantive law actually interacts with the sanction issue. For instance, there might be a case then you can apply English law in the dispute between the parties who are not from sanctioned countries and who has not problems with each other, and the transaction is a simple trade transaction. And in this case, the sanctions, even if they are introduced by England, they would not somehow influence on their particular transactions, even though if the English substantive law would be applicable. So my point is that the issue should be analyzed in each particular case separately, and it does not expressly follows from the wording of these articles of the Commercial Procedure Code that the applicable substantive law could be the only factor to establish exclusive jurisdiction of Russian courts.
Thank you, Sergey. So next question is from Dmitry. So basically it's whether the penalty that was mentioned in the context of Article 248.2, and we said that it's up to the entire amount of claim plus legal costs. So Dmitry is asking whose legal costs, whether it's the claimant, respondent. Perhaps Vladimir, you could answer that.
Legal costs, I think that it covers legal costs of the affected party, of the party affected by sanctions, clearly. And it also involves an amount which is claimed from this affected party in a different jurisdiction. And this amount actually may also include the legal costs of the claimant. So, but I think that in this particular case, legal costs are legal costs of a Russian affected party.
Yeah. And of course, worth mentioning that very often the claims are inflated. That's parties to arbitration claim more than they expect to recover. So, and of course, interestingly, the penalty won't be paid to the Russian state. The penalty is in favor of the affected Russian sanctioned party, which is also of interest. Okay, so next question is from Vadim Vunikyan. Vadim wants us to agree a little bit more into the ruling of the Supreme Court on Ural-Vagon Zavod. So I think the key in a long question is whether effectively the onus now is on the non-sanctioned party to prove that sanctions do not limit ability of the sanctions party to arbitrate abroad, rather than to change it from whereas before it was the Russian party which had to prove that its access to justice is limited. Colleagues, what's your view on that?
If I start, I believe that it's not now a question of the burden of proof. It's more simply the position that if the litigation or arbitration take place in a country which issued sanction against affecting a Russian person, this is a fundamental problem, and even reputationally, as the judges of the Supreme Court of the Russian Federation said, that even reputationally, this affected person is adversely affected by the sanctions. So there is no guarantee of objective impartiality here. So in other words, it's not something which can be proven or demonstrated. This is a question of objective impartiality, which is and now given, especially given the interpretation by Judge Patnosova, which is also important and give a bit even more broad analysis of this issue. I believe that it's not a question of burden of proof. It's more it's more hard interpretation, and that's it. It doesn't give you a chance to argue otherwise. And actually, it's a big problem because it's not clear what is the sanctions generally. She said that this is a political sanction, but the raise of tariffs, it's also a sanction to some extent. It also can be viewed as an economic sanction, but everyone raises tariffs or taxes, for example. So it's very tricky point here, but I don't think that it's something about burden of proof.
Thank you, Vladimir. Sergey, what is
yes, I will answer the last part of the question, which is devoted to the amicus curiae. So Vadim is asking that in amicus we mostly argued that the court rendered a decision examining all relevant circumstances of the case. So the second approach which I described, and the question is that whether we analyzed the rules related to allocation of burden of proof. Well, to a certain extent, I agree with Vladimir. If we believe in the concept of the second approach, that the party should prove that actually the sanctions precludes it from taking part in the foreign proceedings. Well, we tried to analyze it from this angle of allocation of burden of proof. However, in the end of the day, it appeared that it could only weaken our position in amicus, because the issue of allocation of burden of proof is rather a procedural one. And it depends on the particular rules in procedural code of the jurisdiction, so which might be different. And in our opinion, there was no need to actually weaken the substance of the analysis because the conclusion that the burden of proof is on interested party might be made from the text of Article 248.2 of the Commercial Procedure Code, because it clearly says that wait a second. The party seeking the injunction is required to prove the circumstances confirming the exclusive jurisdiction of Russian commercial courts. So the burden of proof is on interested party. And therefore, we did not concentrate on this in detail.
Just in this context, it's important that the Supreme Court interpreted this provision. And actually, you may see that what was important there, that it stated that if there is arbitration, if there is an arbitration agreement, it should be added, should be produced that it's not operable, basically. And the Supreme Court interprets this as this is not a binding point. It's also basically what they said is that it's only sufficient for you to show that the place of the arbitration of litigation is the jurisdiction which issued a joint sanctions against Russia affecting the the respective person, and that's it. It's sufficient for Russian court to assume exclusive jurisdiction and to grant the anti-suit injunction if necessary. So they were quite clear on that, in my view. And actually, in the Supreme Court, it took 2 oral hearings. We tried to argue that Russian judges they should have a discretion to take jurisdiction or to not to take jurisdiction. They should have a discretion, but because the judges would say that it's not a question of discretion, it's a question of law, that there is an exclusive jurisdiction. That's it, basically. Another interesting question is what to do with a foreign litigant who are also subject to sanctions of Russia, counter sanctions of Russia. For example, if both parties to the dispute are subject to sanctions of all countries, like how the case will be decided, but the judges deal with the case, with the issue only from a Russian procedural perspective, and that's it.
Thank you, colleagues. I actually do agree with Vladimir's view on that. So I think that's the position of the Supreme Court is quite clear that that's the only thing that the party really needs to prove is that there are sanctions that apply to. So if it's on the sanctions list, then that's it. So it has proven its case. Okay, so we have another question also from Vadim as to whether we think that the new draft law that was mentioned, whether it would, if adopted, would change or broaden the scope of Article 248.1 of the Arbitration Procedure Code. Frankly, to me, it looks like this needs to be looked at as a standalone a legal act. So if adopted, it would effectively impose liability on parties that actually comply with sanctions. So in the practical context, for example, if there is a non-Russian counterparty which is a party to a transaction with a Russian party, the Russian party becomes an SDN, so foreign party cannot perform because it would risk breaching sanctions and would breach being subject to penalties imposed, say, by the US or EU, etc. So what this new draft law says that if a foreign party terminates contracts by following sanctions, then it would be subject to that new Russian counter-sanctions law and would be penalized by the Russian state for complying with the sanctions. That's my take on this new draft law. Vladimir, Sergey, what do you think about that?
I agree from my perspective, because I believe that it's not a procedural stuff, it's more substantive stuff. It's a new liability issue. So it's not kind of it's not a question of procedural court, it's more substantive law.
Well, but anyway, the question was whether it expands the scope of Article 248.1, and technically it does expand the scope because I went through the text of the bill because I had a link in my presentation and it was quite convenient for me. And indeed, although there is only one article there which says that the article of 248.1 should be added with a new category of disputes, meaning the disputes between Russian and foreign person with other Russian and foreign person, if the latter one directly or indirectly contributed to sanctions, and that is important, or has not executed the contract. And it is not clear what does the wording and or means, because it is clear for me that if the party contributed to sanctions and didn't execute the contract, so in this case, probably the scope of the article is not extended actually. But if we should separate these two situations, there will be an extension indeed. However, this is too early to discuss this, in my opinion, because what happens actually, we see what happens with the proposed bills. They could be subject to discussion for years. they could be amended several times, and we will see how the document would be amended, or whether it would be considered at all.
Thank you, Sergey. I agree with you. It's a bit premature, and that laws may well change. If we take this Lugavo law, for example, when it was first introduced in 2019, it was not structured as an amendment to the Arbitration Procedure Code. It was drafted initially as a standalone sort of anti-sanctions law, and then later on it was transformed into the amendment to the specific article of the Arbitration Procedure Code. So anything may well happen to this draft law. It's still a very early stage. Thank you. We have already a little bit overrun our time frame, but I believe that in the interest of the discussion, we shall continue. And thanks for everyone staying with us. So let us address, I think, a very important point made by Dmitry Markulev as to whether we think that the Supreme Court's position on PESA case applies to Russian arbitration institutions. So just to perhaps clarify the question for the audience, the thing is that the provisions of the Arbitration Procedure Code are drafted in a slightly ambiguous way. So technically, it looks like they apply. It's not clear whether they apply to Russian arbitration institutions. And personally, I do not think that it was the purpose of the lawmaker to make it more difficult to arbitrate in Russian arbitration institutions, but it's not evident from the text of the law. So I suppose the question Dmitry is asking us as to whether we think that the position of the Supreme Court now makes it any more clear. So what would be the future of a dispute referred to the jurisdiction of the Russian arbitration institution with the place of arbitration in Russia? So whether these provisions should apply, if at all. Colleagues, what do you think?
I think that generally the arbitration in Russia is encouraged. So I don't think that, I think the purpose of Article 248.1 and .2 are to prevent arbitration or litigation outside of Russia, where in the country which issued sanctions, basically, for all sorts of reasons. So I think that Russian arbitration would be, on the opposite, Russian arbitration would be encouraged, and I don't interpret the ruling of the Supreme Court that it should raise an issue with Russian arbitration institutions. I don't think that it should be interpreted this way. I think that there should be no problem with the objective impartiality test in Russia. However, it still can be an issue with a subjective impartiality. For example, if the tribunal consists of English citizens, or citizens from the country which also introduced sanctions, something like this. So it's another kind of issue. But as it is, I don't think that there is an issue with the Russian relations.
Thank you, Vladimir. Sergey?
Yeah, I'm on the same opinion as well. And well, the wording of the Commercial Procedure Court is ambiguous indeed. However, with respect to particular provisions related to injunction, this is Article 248.2 of the Commercial Procedure Code. It's stated in the first part of this article that the party against which there is a proceedings initiated, or there would be initiated the proceedings in the future in the foreign court or international commercial arbitration located outside Russia. So this particular provision related to injunction applies to the commercial arbitration proceedings which take place outside Russia, and therefore Russian into domestic arbitration proceedings should not be affected, in my opinion, by the Lugovoy law. As to the second part of the question of Dmitry Modukevich with respect to the neutral forums, such as Hong Kong, for example, well, in my opinion, it also these situations are also not covered by this article, but this is rather an interpretation. This is not follows directly from the wording of the article. And here I also thought about this when I first read the judgment in Ural-Transmash case. And something in the judgment itself made for me clear that so far the new provisions of the court, according to or new provisions of this anti-sanction law, do not apply to the neutral arbitration forums. So there is still a chance to resolve your dispute in the neutral forum, indeed, such as Singapore or Hong Kong. However, we should see how the case law would be developed. And we will soon see this, given that the popularity of Asian arbitration centers increased during the last years.
Thank you, Sergey, and I agree with you and with Vladimir. And I think Vladimir made a very good point that we shall assess not just whether the arbitration institution is in a jurisdiction that imposes sanctions, but also the composition of the arbitration tribunal, whether individual arbitrators are citizens of the jurisdictions that have imposed sanctions, and also the applicable law, because the complexity is that Russian arbitration institution may need to apply English law as the law of the contract. So, and that if sanctions are sort of a part of the applicable law, such as English law, then that may become a problem. But that is a really complex issue that was not looked at by the Supreme Court in this case. So there are many questions that still remain. But thanks to colleagues, thanks to Dmitry for an excellent question. Now, another question from Anton Maltsev, who attracts our attention to the risk posed by enforceability of Russian state courts by courts in the CIS countries, the Commonwealth of Independent States, former jurisdictions of the Soviet Union. I think that Anton here refers to the treaties that Russia have with many CIS countries on mutual recognition of court judgments. So that is indeed a risk. I would add that Russia has treaties like that, not just with CIS countries, but with many other jurisdictions, Mongolia, for example, but also some of the EU jurisdictions, such as Cyprus and Spain. For example, but you see there may well be a clash if there is an arbitral award on the one hand, and then a decision of the Russian courts on the other hand. In my view, most courts in the EU are likely to be more pro arbitration, and are more likely to enforce the arbitral award pursuant to the New York Convention, and will give it precedence over decision by the Russian court, which might be the opposite. But again, that would very much boil down to details of a particular case and would be decided by each court outside Russia on an ad hoc basis, in my view. Vladimir, Sergey, what do you think?
I agree with you. I think this is a question of bilateral agreements. For example, with Cyprus, there are limited grounds to resist enforcement of a Russian court ruling, for example, under the treaty. So we need just to be careful. And I'm sure that within CIS countries, they wouldn't be too much concerned about the fact that the Russian court decision maybe against the public order of some EU countries. They will view this from their own perspective only. The same China and Asian countries. So I would say that we shouldn't underestimate or ignore Russian court decisions, which can be issued in accordance with Article 248.1 and .2, because I suspect this, if, for example, the exclusive jurisdiction of Chinese courts are not breached by Russian courts, but Russian courts breach exclusive jurisdiction of let's say Danish courts, there is no reason for the Chinese courts not to recognize decision of the Russian court situation. So I think that this is it really depends on the situation. It should be decided on case-by-case basis, and also the question who applied first for recognition of the Russian court decision or for arbitral awards. And paradoxically, in some countries, it's maybe easier to enforce Russian court decisions as opposed to international arbitral awards. So I think, yes, it's case-by-case basis, but it's not, I don't think that this type of Russian decision are closed in Russia and you cannot do anything with them only in Russia. It's not the case in my view. Sergey?
Thank you. Sergey?
Well, as to the issue of enforceability, the thing is that in most, or at least in part of the international agreements which I am aware of, the violation of the exclusive jurisdiction of certain member state is a ground to deny a recognition and enforcement of the judgment. Therefore, in my opinion, the specific attention is given in international agreement with respect to the situation when one member state has exclusive jurisdiction over a dispute, and exclusive jurisdiction obviously follows from the domestic legislation of the member states. Now, therefore, in my opinion, there is a room for discussion indeed. But at the same time, there are strong arguments in favor of recognition of Russian court judgments from the legal point of view. If Article 248.1 of the Commercial Procedure Code specifically state that these disputes fall within the scope of the exclusive jurisdiction of the Russian courts. That is why, in my opinion, there is an issue, of course, as Anton highlighted, but there are strong arguments in favor of recognition of Russian courts' judgments.
Thank you, Sergey. And of course, likewise, I think it's worth mentioning that if there is an arbitral award issued outside Russia, which would be contrary to these anti-sanctions provisions, then such award won't be enforceable in Russia, and Russian court is likely to argue that would invoke Article 6 of the New York Convention and would say that it's contrary to Russian public law, public order, because certainly these anti-sanctions provisions of the Russian Arbitration Procedure Code would certainly be considered part of the public policy in Russia, or super sort of mandatory rules of Russian law. Well, I don't think we have any further questions from the audience. We might be able to open up floor for live questions. I don't know if organizers allow that. So if anyone in the audience would like to raise their hands if they want to ask any questions live, then I may ask organizers to let them do that.
While we're waiting, I have one tricky questions to other members of the distinguished panel. So what would be your recommendation to the client, whether to execute Russian court anti-suit injunctions or not, whether to continue proceedings in foreign arbitration or foreign court, or to apply Russian court?
Vladimir?
Well, I think this is a very fact-specific issue. So first, we need to understand who is our client, and second, if our client is subject to potential anti-suit, we need to decide what is its exposure to Russia or countries where the Russian anti-suit would likely be enforceable. And depending on that, the advice can be structured. Really, it's not a good, it really depends where the assets are, what is the subject matter of the dispute, and where the arbitration award or a foreign court judgment is going to be enforced also. For example, if a Russian counterparty have an assets outside of Russia, they can be subject to enforcement also. So I think it's a very practical, the advice will be very practical, and it's not possible to give a general advice. But general point is that it's better to comply with the judgments if possible, depending on the situation. But if you're supposed to lose for any reasons, you need to consider from practical perspective what to do, what is better. You can also apply for anti-suit injunction in London, for example, against a Russian company, and everyone will have their anti-suit injunction against each other. It's also can be a case, So it's really the question of where you wish to litigate and what would be the benefit for you.
I agree with Vladimir. It's very case specific. In my view, ultimately, the key question is where the assets are of both parties. So if you can enforce against respondents' assets outside Russia, then arbitrating outside of Russia is a good idea, provided that your own assets in Russia are not at risk if there is a Russian anti-suit injunction. So you need to balance these two considerations. But I think ultimately, my recommendation generally would be to consider seriously choosing the forum that is not in jurisdiction that has imposed sanctions. So either Singapore, Hong Kong, or even a Russian forum that might be perfect from the standpoint of Russian law, because I think that it is the strongest argument that a Russian forum with a place of arbitration in Russia that does not create any limitation or impediment for the sanctioned party to arbitrate in Russia.
That's what the Lugovoy law is all about. It kindly invites the parties to Russian forum, not arbitration, unfortunately, but the commercial court. But here's the option. Yeah, so we'll see everyone in the commercial court of Moscow with their multi-billion claims resolved by the judges who have more than 40 or 60 hearings per day. So that would be quite a challenge.
Oh, yes, indeed. But my point was that if you choose Russian arbitration tribunal, Russian arbitral institution, as opposed to state courts, then although, as we discussed, it's not 100% clear from the wording of the law whether it would impact such proceedings. But I think, as we tend to agree or have agreed on this panel, that it is unlikely that the law would restrict parties' ability to arbitrate in a Russian arbitral institution. So therefore, I think this could be a good compromise. But if that is not acceptable for any reason to parties of the transaction, then looking at Singapore and Hong Kong could be sort of a further compromise, which is still not immune from various problems, because the problems that we mentioned, such as, for example, payment of fees, that could well apply there as well, and instructing counsel and things like that would still remain as issues. So therefore, please, I would urge everyone not to think that is a catch-all or a resolve-all solution, unfortunately, but this could be a mitigating factor, a compromise. Right, I don't think we have any questions from the audience, nor we have volunteers to ask questions live. So we have already overrun half an hour, but it was such an amazing discussion. So let me thank, of course, my panelists and everyone who stayed with us for such a long period of time, and indeed Russian Arbitration Association for organizing that. We didn't really have time to go in detail through the survey, so I would encourage everyone to visit the website of Russian Arbitration Association, where you can look at the materials of the survey in more detail, because that is really of great interest. So I would really encourage everyone to do so. And of course, I would close with our joint wishes of recovery to Roman, and we hope that you feel great very, very soon. Thank you, colleagues, and thanks to everyone who was with us tonight. Thank you.
Thanks, everyone.
Thank you.